Welcome back, everybody. This is Brennan Aberle, one of the partners at Aberle and Wall, and we are here for our third class that we're teaching. This one is 10 Uncommon Tips for Protecting Defendants, and I have a special guest, my co-counsel and law partner here at Aberle and Wall. Julie is here with me.
Hi, thanks, Brennan. I'm Julie Wall, and I have been able to join Brennan for this one. So this has been a team effort that we've put together. I just want to say thanks to everybody who has jumped online for these CLEs. I have to say, Brennan's worked really hard, and we both worked hard on this one, and we're thrilled at the turnout. Thank you for taking advantage of the time that we've put into these, and we'll just ask people if there are any ideas for other topics that we might be able to put together. If you want to send us an email or put a comment in the chat box that pops up at the bottom, we're open to that. But thanks to everybody for giving us your time during quarantine, and we're just trying to make the most of it because we want to continue to be a resource for the community. And if you've got any ideas about how we can better do that, just let us know.
So thanks, Julie. Before we get started with the 10 tips themselves, thought it would be a good idea to kind of mention just we like to throw out practice points when we can. And as an attorney, you're going to have to find your own voice. You will find that certain strategies work better for you or your clients than maybe other attorneys do. You may also find that not every case requires you to use a hammer to solve the problem. So we pulled out 10 that were kind of fun, that are a little bit lesser used, but you certainly don't and shouldn't use all of these or even necessarily any of these for every single case that you have. You kind of just have to feel it out, try to know your case in and out and assess for yourself whether you think you're going to end up causing more problems for your client by filing or arguing some of these things, or if you may put your client in a better position. And I think ultimately it'll be a little fact specific, but we came up with 10 ones that are kind of fun. But that would be my advice about that. What do you think about that, Julie?
I think definitely, with the exception of one of these, which is just, I'll talk about it in the segment, but objecting in writing to Kim analysts and chain of command. The rest of these are all, chain of custody. The rest of these all really do need some finesse. I think just because this tool exists, you don't need to necessarily shove it down the prosecutor's throat every time. If you pick and choose and you use them in the right cases, you're going to still be able to use them in the future. And you're also not going to damage your future client's chances of getting good outcomes. So I think Brennan's right. These are definitely to be used with some finesse and just really assess when they're appropriate.
So what I will do is throughout the course of this video, as we go from tip to tip, you'll see that down in the YouTube explanation section, I've put some timestamps in there. So if one of these topics comes up and you think about it again and you think you wanted to kind of refresh your memory on it a little bit, we're going to try to give you case citations and statutes when it's applicable. We'll try to point you to some resources when it's applicable, but I'll try to put some timestamps in there so that you can kind of jump easily between it if you ever review this video again. So without further ado, we'll go ahead and get started. All right, so one of my more favorite tips that is highly underutilized is the motion for a definite trial date, and that is North Carolina General Statute 7A-49.4 subsection C. I do have a sample motion on my website if you are interested in using it. This is a great one because it weaves together a lot of kind of hot button issues, the right to a speedy trial, and the big question of, in North Carolina, by statute, the district attorneys have the calendaring power, but there is a lot of dispute among how pervasive that actually is, and a lot of good cases show that the prosecutor's office actually shares calendaring power with the judges, and no calendaring power overrides your constitutional rights to a speedy trial. So this kind of weaves together a lot of interesting issues. Let me set aside motion for a definite trial date for a second and talk about your right to a speedy trial. So the Sixth Amendment guarantees your client the right to a speedy trial, and the seminal case that covers that is Barker v. Wingo. And the Barker v. Wingo factors are these 4 factors that the court looks at to decide if your client's right to a speedy trial has been denied. Those factors are the length of the delay, the reason for the delay, the timeliness of asserting the right, and whether your client suffered actual prejudice. Length of the delay is going to depend. For misdemeanors, it can be a lot shorter, and there's actually case law in North Carolina on that. Those cases are not complex. They're not hard to try. A shorter delay, and you can file a motion to dismiss for violation of Sixth Amendment speedy trial rights in a misdemeanor case than a felony. There is no bright line rule here, but generally the longer the delay, the easier it's going to be to show that there's been prejudice in the final factor. The reason for the delay, you're going to want to keep notes on this. Were they neutral reasons about, like something like coronavirus has shut down the courts, or was it that a prosecutor was refusing to calendar a case or something like that? That's going to be very fact specific. The next factor is timeliness of asserting the right, and this is key here. This is why the motion for a definite trial date is so great to talk about, is because a lot of these speedy trial cases end up failing because the courts have noticed there's a difference between asserting the remedy, which is dismissal, is what you want, versus asserting the right to a speedy trial. And you do not assert the right to a speedy trial by asking for a dismissal. You assert the right to a speedy trial by opposing a continuance or rejecting a plea or asking for a trial date or something like that. The final factor is prejudice. If your client's in jail, they're definitely suffering prejudice. That's very easy to show. If they're out of jail, lost wages, economic opportunity, getting passed over for jobs, witnesses losing their memory, it can go on and on and on to show prejudice. But the worse the first 3 factors are, or rather the better they are for the defendant, the less you have to show on prejudice. But the reason why a motion for a definite trial date is good is you will never get burned for not having asserted the right if you file a motion for a definite trial date. And that statute basically says that you have to wait for 120 days from either indictment or notice of indictment. And if the case has not been calendared for trial, you can have a hearing on what a definite trial date for that case would be. Now, this is all going to need to come down to your own gut feeling on tactics and strategy. Filing a motion to dismiss for violation of a speedy trial right sometimes, for whatever reason, is considered a nuclear option, even if your client is certainly entitled to it. But a motion for a definite trial date is a little bit of a softer approach, and really you can do it in a non-personal way just by saying you're covering your bases because it's important for you to put this on the record so that if you ever did have a speedy trial hearing down the road, you can show that you've asserted the right. And actually the language I put in the sample motion that I put on my website kind of says that it's a little bit softer approach. But it will get you a chance to get in front of a judge and show the judge that, hey, look, it's been some time. We do want a trial on this. We haven't had a hearing. And that can have its own benefits. If your client really does want the trial, then it's going to help you move it along faster. It's going to put a judge's eyes on this case and have an order that the case be tried by a certain date. It can also sometimes move along negotiations if there's some trouble in getting witnesses or whatever. Rather than have a whole hearing on this, it may help foster some type of plea resolution that maybe is all you've really been looking for. So, there's a couple ways to do it. Filing the written motion. You could put it in your motion for discovery, but I tried that in the past, and I was met with the feeling that I was requesting a trial in every case, which you certainly are not. So use it where appropriate. file a written motion. You can go down to the clerk's office and put it there, and then request a hearing on it. And it is a good extra tool to have for you available if you decide that you need a little extra nudge to push this case along towards a resolution of some kind. So that is the motion for definite trial date.
I'm going to talk a little bit about the Fifth Amendment and specifically how it applies in domestic cases to civilian witnesses. We in Guilford County currently are dealing with a situation where our district attorney's office has a no dismissal policy for any domestic cases. And one of the things that frequently comes up is when a witness or a victim doesn't want to testify. We are not allowed ethically to simply advise them directly and to bring this up with them. However, we can tell them that they do have rights under the Fifth Amendment if they solicit that information from us. And we then need to advise them to get independent legal advice from another attorney. I think many of you have found that there are a lot of us who are very willing to exchange that favor for each other when that's asked and pop over in the courtroom and address this. But the Fifth Amendment allows them not only to not testify, but it applies under specific guidelines, specific conditions. And occasionally we're starting to see some pushback from this. So I think it's very important to be sure that we know where it applies, and so that we can also help judges make the right determination if the judges do get a little bit hesitant on a certain witness or if a DA is pushing the issue. So it has to be in a situation where the witness or victim does not have any immunity against prosecution, so there's something on the line there, and where their testimony may either be incriminating itself or it may lead to information that could be incriminating. And then the third criteria is just that they have to say it in a timely manner. They have to assert that right prior to answering the question. And it's also important that if you are advising, let's say if you are that independent counsel who's advising a person who is a victim or a witness in a case, that they need to be aware that they can't testify on direct for the state, for example, and then try to plead the Fifth on cross. They're going to need to do it early. As we all see, it tends to happen, most of us, if we are there and we have a client who is asserting that, especially in a cross warrant case, where we need to get that out there early and right away. Let the court know. The state has talked a little bit about pushing back against that. I've seen some movement by a couple of prosecutors in that direction. And I think it's key to know that the judge is the one who ultimately makes that finding. And there are definitely lots of opinions out there that say that it should be construed very liberally, which gives judges a lot of latitude. So they need to err on the side of approving and understanding that even if the state's objecting, we really need to push back and encourage our judges to be pretty liberal in their granting of that privilege, because it is so important and it's so crucial in these cases.
All right, so the next two topics are related, but they are not the same thing. It is the fatal defect or the fatal variance, and they both have to do with what are the words in the pleading document. That may be the indictment if we're in superior court. It may be the citation or a warrant for arrest if we're in district court, but that pleading has to contain certain requirements, and those requirements are generally set out in 15A-924. It says what a pleading must contain: defendant's name, name of victim, concise statement of the charges. It includes generally what the statute is. Now, the difference between defects and variances, here's the easiest way to think about it. I'm going to talk to you about defects first, and then we'll jump over to my law partner, Julie, about variances. But defects, the easiest way to think about it is Defects are whether a crime is properly charged at all, and that goes to not just your statutory under 15A-924, not just your statutory right to be made aware of what the charges are against your client, but you also have a constitutional right. And don't let anyone tell you this is some technicality, because that's BS. It is not. It is your constitutional procedural due process rights under the 5th and 14th Amendments of the United States Constitution. You have due process rights to be made aware of what the charges are against you, because that is a great part of our system, that you can have the ease and peace of mind of knowing what you're supposed to be defending against, so you're not subjected to trial by ambush. Okay, so it's not a technicality. This is an important procedural right that your client has, that we all have as United States citizens. So defects have to do with whether there's a criminal charge that is actually on paper against your client. That's a jurisdictional issue, and you can raise it at any time. You can raise it pre-trial. You can raise it during trial. You can raise it after trial, even if your client is found guilty, if it is a true jurisdictional defect. I'll come into some reasons why you'd want to do both. I'll say really quickly, Julie's going to get into variances. Variances are a lot more like your motion to dismiss because the evidence is insufficient. It's that there may be a correct crime charged, but the evidence at trial is not the evidence that the state said they would show. It's a little nuanced. I'll leave that for the next section. But for pleading defects, one place I would encourage you to go, other than that statute, is Jessica Smith of the School of Government, North Carolina School of Government, put forth a great defects and variances pleadings paper that you can find relatively easily on that site. And it kind of summarizes each crime is specific. There's lots of case law that has developed over the last several years that kind of get into the meat of this, and each one of those requirements that a pleading must have. Sometimes there's case law that's good for us. Sometimes there's not, on whether it is a true defect. But I'll give you an example. So, one of the things that has to be alleged, and it's under the victim's name portion, certainly for a crime like a property crime, one of the elements of the offense is that you have to have taken property from another, and another is an entity that is capable of owning property. And so that's a common one we talk about, where your client's charged with misdemeanor larceny from Food Lion, and it just says Food Lion instead of Food Lion, Inc. or LLC or whatever the corporate name of Food Lion is. That's a defect, and it's a jurisdictional defect because it's not alleging an entity that is actually capable of owning property. Why? Because Food Lion isn't a thing. Food Lion Inc. may be a thing, but Food Lion isn't a thing. You'll get citations sometimes, kind of lazy citations that say your client's charged with misdemeanor child abuse, and then it doesn't say how. It doesn't describe it at all. It doesn't say, misdemeanor child abuse has several different theories, like substantial risk of physical harm or intentionally inflicting. So there's all these different theories, and it is not a technicality to suggest that your client has the right to know what the charge is against them, what exactly it is. When you have a jurisdictional defect like that, you can raise it pre-trial, and then if a prosecutor wants, they can ask for an amendment to certain things that they're allowed to. They can't amend every part of a pleading, but they can amend some. They can ask for an amendment. If they do, you're entitled to a continuance, so you can continue it. If you've set a case for trial and you don't want to try it that day and there is a defect, if you want to bring it up pre-trial because all you're trying to get is the continuance, you'll be entitled to one if the judge grants one. Grants an amendment to the pleading. You're entitled to the continuance. The next issue then becomes, one reason you might want to wait is, well, if you wait for the case to start and a witness is sworn, then a dismissal is going to have to be entered. And there's a good question about whether the judge grants that as a mistrial or whether it's actually a dismissal. Um, there's some interesting School of Government articles on that and whether jeopardy has actually attached. But you may want to wait until a witness is sworn because it's going to result in a dismissal that may or may not be able to be refiled depending on the specifics of what the defect is. And then finally, with jurisdictional defects, you can wait until the end. You could go to trial with a good theory of defense, believe that you're going to win because you think the evidence doesn't support conviction. Your client gets convicted at a bench trial that you didn't expect, and then you can raise the jurisdictional defect. And after the conviction, the case still has to be dismissed if there truly is a jurisdictional pleading defect. So that's a great tool to use. Sometimes it can allow you a couple of bites at the apple. And sometimes, even though some of these charges can be refiled, sometimes they just simply won't be. So getting that quick dismissal may benefit you down the road because we may move on to the next of 400 cases on the docket that day, and that just be the end of that case. So that's defects, a lot of specifics. There's a lot of nuance to it. I encourage you to read the Jessica Smith article, but there are a lot of ways in there that you might be able to fight a case that you weren't thinking about when you were just trying to come up with theories of innocence.
So Brennan was just talking about fatal defects, and I'm going to move from there and talk about fatal variances. A fatal defect is something that can be raised at any time, and he's explained why that is. The big important thing and what divides it from a fatal defect is that a variance is when the evidence at the trial does not meet all the essential elements that are required based on the indictment. So that is something that has to be raised at trial. You must make a motion to dismiss based on that fatal variance. And an example of that would be if the indictment alleges that the defendant stole or took by force the cell phone that was being held by John Doe. And then at the close of the state's evidence, it's clear that John Doe was not the one who was holding that cell phone or who owned the phone, that the evidence shows that that was instead Jane Smith's cell phone, and that the defendant is alleged to have taken that cell phone by force from Jane Smith. That is a fatal variance. You need to make a motion at the close of the state's evidence to dismiss based on the fact that the facts vary from the indictment. It's something that happens off and on depending on the drafting of the indictments, and it also depends very much on what the witnesses say and what the evidence bears out in trial. It's crucial that you pay attention to those details, and it's extremely important that you keep on top of that at the beginning of the case, that you carefully read those indictments before you start the trial, and then that you look back at your evidence and assess whether everything matches up there. And I've referred to indictments, but this is also crucial with regard to the elements alleged in the warrant in district court. So it's applicable at both district and superior court. The problem is that in superior court, like many things, it must be argued and objected to, or the motion must be made at trial. It can't be brought up on appeal. So in order to fully protect your client, fully protect the potential for appeal, you've got to raise that issue and raise it at the close of the state's evidence, and then again at the close of all evidence if it's not granted initially on your first motion. And if you do that, you will protect your client. Even if it's not granted, then an appellate defender will be able to do with that what they can. So keep that in mind, and that's what is different from a fatal defect, which is going to be defective on its face, and a fatal variance could end up getting charges dismissed for you at the close of the state's evidence or at the end of the trial.
So here's a fun one, and I'm going to call it speedy trial or discharge on commitment of a felony, because that is what it is called in North Carolina General Statute 15-10. This is a fun one and a great example of what we said earlier about you really should read through the not just 15A where we think everything is, but there are other sections of the statute books that cover just there's a lot of gems and a lot of fun different little rules and protections for your client that you may not know exist. So this one is a statute that requires that your client be released from jail if you demand in open court that they be released while it's a felony in district court, and your client is not indicted on the next term of court that there is grand jury. Now, the judge can extend that period up to 120 days, but after 120 days, if your client has not been indicted, they have to be released. This is a very narrow, obviously, tool. It's kind of an archaic statute that is a little bit difficult to understand from the wording of it, but it has been interpreted in case law, specifically a 1974 case called State v. Wilburn, to require this. So it's related to speedy trials. It's going to involve your client being charged with a felony and being in district court, and they have not been indicted yet, and you have to ask for this in open court. But if you ask for it in open court, your client has to be indicted at the next grand jury, or they have to be released. And if that, the last sentence of it says the judge has discretion to extend that unless 120 days are passed, and then there is no discretion. This would be kind of an unusual thing, but again, you find sometimes that they don't want to indict a case because they're waiting on the feds to do something. This might come in handy for you. I would also suggest, as another bit of a practice point for you, where I got this one and where you can find a lot of these interesting little rules that you may not have known existed, is using so I always love to give a shout out to the North Carolina School of Government. And in this case, John Rubin put out the Defender Manual for indigent defenders, but it is available online. You can read it. This one, I got a tip off from one of my favorite defense attorneys who I highly respect, Mr. Richard Wells, but that is available under the Speedy Trial and Related Statutes section of the North Carolina Defender Manual. So if you just get on Google and type in, School of Government, North Carolina Defender Manual, it's very easily indexed and an easy way to find a lot of these issues. But it's an interesting statute. It's a little trick most people don't know about because it's an old kind of archaic statute, which you might use to your advantage in these limited circumstances. But even though North Carolina's speedy trial statutes have been repealed, there are little remnants of it that are useful, and this is one of them. So throw that out there. If the case just fails to go to grand jury a couple of times because somebody forgot about it, while a district court still has jurisdiction, the remedy is that your client has to be released from custody. So that's another fun little trick.
In this segment, I want to talk a little bit about the writ of habeas corpus. It is a constitutional right, and it's fascinatingly somewhat even broadened by the North Carolina Constitution from the federal Constitution. And then our statutes make some very, very specific and important statements about how crucial habeas corpus is and an individual's right to demand a showing by the state that they do indeed have legal justification to hold or detain someone physically. This is about your liberties. It's about our clients' liberties. And this goes historically all the way back to the Magna Carta and has really detailed history that I will not get into today. but that essentially leads us to the North Carolina Constitution. And Section 21 of the Constitution says, every person restrained of his liberty is entitled to a remedy to inquire into the lawfulness thereof and to remove the restraint if unlawful, and that remedy shall not be denied or delayed. The privilege of the writ of habeas corpus shall not be suspended. And then we jump over to Chapter 17, and Chapter 17 of the General Statutes just parrot that word for word. It's 17-1, begins and ends word for word exactly with the constitutional provision. And then moves on to 17.2, that it then again parrots that the privileges of the writ of habeas corpus shall not be suspended. Both of these just reference back to the Constitution, but Chapter 17 is a very useful read to go through and look at when you might be able to argue that your client's imprisonment or restraint of liberty may not be lawful, may be unconstitutional. I want to go through 3 specific instances today that are not going to come up all the time, but if they do, we all need to be aware. We need to be ready to issue spot and ready to go ahead and file that writ to force the court to show why it is that they think that they've got the authority to restrain or detain our clients in the custody. The first of those issues is if there is a situation where a defendant has been on probation. Now, granted, this is going to be after the fact and after probation's been activated, but the criteria are: 1, they were on probation; 2, the violation report was filed after the term of probation ended. So after that expiration date from the original judgment. And then 3, you also need to make sure that that period of time was not extended or tolled. Situations where you'd see that would be where if a judge had extended the probation due to a previous probation violation to give this person more time to comply or more time to be supervised. Those would be times where this would not work if the probation had been extended further. But if someone goes into custody and their probationary sentence has been activated under these circumstances, and again, that's on probation, violation report filed after the expiration of that period, and nothing had been done to toll that period or extend it, and they're now in custody, they're not rightfully in custody. They are not constitutionally detained. And so this would be an after the fact remedy for them, but also you would want to keep in mind that now that we in Guilford County are switching from most of the cases staying in the public defender's office with a couple of people, which they have for years. They've tried not to farm out very much. Now we're looking at the situation where the policy has changed and the public defender's office is going to be outsourcing more and more of these. So changes in our local policies with regard to how cases are being assigned have happened fairly recently, and the public defender's office sending those cases out into the general defense bar, the indigent list for those who are on the roster to receive those cases are going to be more likely to get more probation violation cases. So I think it's important that people understand that if you're doing a review of a case on the back end, a post-conviction, post-sentencing situation for someone, whether you did the case or someone else, where they're in custody under these 3 circumstances, then you're going to want to look for those. But I also think that it's very important for everyone in every case to make sure that this is something that you're checking for. Create a checklist if it helps. Use it for every file, because you're going to want to know One, if they were on probation, when was the termination date of the initial sentence for probation? How long did that probationary period run? Next, you're going to want to check that violation report. When, not when it was signed, but when was it filed? Was it filed before the end of that probationary period was set to terminate? And then number three, confirm that that is indeed the actual termination date and that the period was not extended at a previous probation violation hearing or by consent by the parties due to another violation report. So in those circumstances, you would have grounds to argue for a dismissal in a probation violation hearing. And also you might have the opportunity to do some cleaning up work if those factors weren't confirmed at the beginning. I want to move on to talk about situations with appeals from district court where a writ of habeas corpus could possibly become an advantage. The first one of those is if you are dealing with a situation where oral notice of appeal was given in district court immediately following the sentencing in the case. At that point, if you, for example, had a client who had a written promise to appear and a judge put a secured bond on it, you may be in a good position to argue that they are taken into custody unlawfully against their constitutional rights and to file a writ of habeas corpus. The statutes are very clear with regard to pretrial release and appeal, and there is a strong basis for the determination that a bond must remain as it was previously set in an appeal unless there is some appropriate basis for that bond to be modified. So if there are no new facts, if your client's not been overheard saying that they're going to kill the victim in the case or they're going to leave the state, the facts and the circumstances remain the same as they were when pretrial release was set. And the argument could be then that they have been unlawfully detained and that their liberty is being infringed upon without legal justification. The other basis for a writ of habeas corpus would be in the event of a defendant who files written notice after the fact. The district court is concluded, they have been sentenced, taken into custody, either they had been in custody to begin with or this is new. Regardless, that doesn't matter in this scenario. Once the notice of appeal is filed in writing, the state has 48 hours to get them in front of a judge. If that's not done, and if there is a delay, there is another opportunity to file for a writ of habeas corpus because they cannot be held while the terms of their pretrial release are simply being considered. And the statutes are very clear about that 48-hour rule. So 48 hours, and if that's not done, then jump on it. And that's why it's so important to know these ahead of time. Speaking of 48 hours, that takes me to our third topic. The third issue is in matters where you've got a defendant who is already in custody and is being held on a federal immigration detainer. I think everybody's familiar with the federal immigration detainer. There are two scenarios that might trigger a writ of habeas corpus situation. The first one would be if your client has a hold and has a local bond. Let's say your client has a $3,000 bond that they're being held on for Guilford County. If they make that bond, that starts the clock ticking. I mentioned the 48 hours earlier. This is when the 48 hours start on this kind of a situation. The law says that the local authorities only have to hold this defendant for 48 hours for federal agents from the Department of Homeland Security or ICE to come and pick up this defendant. And the local authorities are only obligated to hold them for 48 hours if they choose to. If they are still being held after 48 hours, that 48 hours and 5 minutes after, file that writ. Now, we're not seeing much of that, thankfully, these days in Guilford County, and it's been a while, but anybody who's been practicing for more than 10 years is familiar with this. We used to deal with this. We used to see defendants being held for federal agents to come and pick them up. Thankfully, we've had a shift, and our current sheriff's deputies under our current administration within the Guilford County Sheriff's Department are not currently complying with that 48-hour hold. So if there's nothing else holding them, they're very likely these days to just simply be released. And we hope that doesn't change anytime soon, very much. But if it does change, just be on the lookout for these scenarios. Because if they do not come within the 48 hours, then you are able to file and argue that they must be released immediately. And it applies both where there's a bond or also if your client has pled to the underlying charges in Guilford County or your home county and is either sentenced to time served or court costs and fines, unsupervised probation. Any of those components would allow for that. So just keep that in mind. And it's worth reading. If you get into this scenario, then you're going to want to read through the statutes that I've cited through Chapter 17 of the general statutes, because it talks about the processes and the procedures. You're going to file this in Superior Court, and there are penalties for judges who do not grant a writ of habeas corpus under legally appropriate scenario. They actually can get fined $2,500 that goes to the defendant. There's also some very almost hilariously antiquated processes and procedures. If you get your writ granted and you have an order, but the sheriff's department refuses to act, your next step is to serve the county coroner, and there are some other really interesting processes where it could lead to the actual elected sheriff being taken into custody, which happens so rarely these days that I don't think anyone ever hears about it for obvious political reasons. But if you find yourself in that scenario, it at least looks like an interesting and exciting prospect of how to go about doing that. So this will just get you on the road to issue spotting these scenarios where you might be able to utilize this really fundamental right that all defendants have.
So the next thing I want to talk to you about is probable cause hearings, and those are located at North Carolina General Statute 15A-606. A couple of undeniable realities about this before I get into it too much. One, if you do it, you will get a lot of pushback. That is that is a sure thing as there is out there. But two, your client has a statutory and arguably constitutional right to it. The statute is very clear. Look it up, read it. Your client's entitled to a probable cause hearing within 15 days. There is one minor exception, but within 15 days of your client being arrested, the state has to put on evidence that there is probable cause that your client committed the crime. And if the state doesn't put that evidence on, the charges can and should be dismissed, or your client should be released from custody. If they are dismissed, it's not with prejudice. The state can refile the charges. So we don't do them here. Your client's entitled to them. There's a reason for that. There is generally a trade-off, and most jurisdictions have some form of trade-off, that there is a type of leniency in a few different ways that you're going to get prior to indictment by not having them. But that doesn't mean that this is a useless tool, and that there aren't times when you can and should do it. I'm not advocating that you do this with any type of regularity. You may find that you never have a circumstance where you need to do this, but it is your ethical. I mean, you're ethically obligated to protect your client. It is a duty, and you can lose your law license if you don't. And there are circumstances where if you've tried everything else, if you have begged and pleaded and been nice, and generally most of the time you're going to get, some type of discovery pre-indictment, or indictment's going to come with a generally quickly. Every now and then there's a circumstance where indictment doesn't come and you felt like you've done everything else you can do. And that would be a time when you can and should file for a probable cause hearing. Now, you're entitled to one within 15 days. That doesn't mean that you have to have it within 15 days as long as you haven't waived it. You may find that filing it is the only thing that's left, and doing so might yield some benefits. I mean, you might find out that the district attorney's office comes back and says, hey, look, if you go ahead and waive this thing, we'll agree to a concession on the bond or something like that. And then it may serve the purpose that you need. There's a downside to it, just one to think about, is if there is a probable cause hearing and a witness testifies under oath at that hearing against your client, and that witness becomes unavailable because they, leave town or whatever, you might find yourself in a situation where that is now the type of out of court statement that is going to be admissible under some other type of exception, like that the declarant has become unavailable. That could alter the future of your case. So that's just, I want you to think about all possible benefits and negatives. But every now and then you have a case where your client's in jail, maybe they're waiting on a federal indictment or something like that. And it just hasn't been indicted and a lot of time has gone by and you feel like you've tried everything you can. Having a probable cause hearing might push things along. Or a case where you trust your client and the evidence is weak, very, very weak, and you just want to show the state that, or show a judge that, and you're not getting it moved along fast enough, and your client is in custody and you want to get them out back to their families. There are limited circumstances where it would make sense to file this. Again, I am not suggesting you do this with any kind of regularity, and I am warning you that sometimes it comes with pushback. For some good reasons, and others, but there are circumstances where this would make sense. Look at the statute, read it. You may find that it is useful for a case of yours, to help move it along and protect your client. So that is probable cause hearings.
So one small tip that really should always be used in any case where you're dealing with a chemical analyst or chain of custody is include an objection to their information coming in automatically. You're going to want to make the state go through its paces. So include this objection in discovery motions, and you want to do this in writing every time. There's really no reason that we should be giving them a freebie on just automatically admitting any evidence. We want to make them go through the steps, and we've got to put them through their paces, because occasionally it may pay off. Now, it's not going to be a key tool in every case, but just keep that in mind. Review your Superior Court written discovery motion, make sure it's in there, get that updated so that you're filing it in every single case. And that way you'll have it when the time comes. If it's got a chemical analyst or you're looking at chain of custody components, that you're going to force the state to put on that proper evidence, because you're not just going to automatically consent to it by failing to object to it. For this segment, I want to talk about Rule 702 of evidence, and specifically its impact on what you can do with it in DWI cases. It may not always work, but this is one of these suggestions that I recommend that you do every time. Some of these tools that we're talking about today are really to be sparingly used when they're appropriate. This is one that applies every time you have a DWI trial. Don't just let HGN testimony and any other expert witness testimony come in without an objection and ask for a voir dire. Rely on Rule 702. I suggest that we all go back and read Rule 702 of evidence every so often and look in there for things that you can just put in your tool belt that you can use to challenge and to question an officer who is testifying about HGN. There are plenty of things you can use in there that may cause especially some less experienced officers to become uncertain of their experience and their knowledge. And if you do this every time, there will be occasions when you're able to successfully keep out some sort of testimony. We've all either been involved in those trials or seen those trials where the officer just can't quite show enough knowledge and experience and training for it to qualify. And we need to fight back against that. You don't need to assume that every officer who takes the stand is going to be capable or experienced enough to establish that baseline expert witness credibility. And we want to push back and make the state do this every single time. No freebies on this one, because this is not going to always work. As a matter of fact, you might get this less than 1% of the time. But if you get it, it's such a victory because we're putting the state through their paces. So go and look at the NHTSA handbook, the standard field sobriety test. That's something in addition to HGN testimony that we want to make sure that the officers are showing that they have had sufficient training and knowledge and can explain their understanding of what those tests are actually showing them. I'm sure most of us know, but NHTSA.gov, NHTSA.gov, it's right there on their main page, and they've got the instructor manuals, the participant manuals. It goes through everything. It's a hefty nearly 600 page volume, and it's there for us to access as well. So keep in mind that while we're pulling out some tools and some tricks in this CLE that are occasionally going to apply to the right cases, this is one that we think needs to happen every single time. And who knows, sometime it might work for you. Just keep trying, keep plugging away at it.
So I saved this one for last because it is a really fun one. It sounds like, why is this a tip? This should be so obvious. But I'm amazed how little we use this weapon, which is really in a world where they make things tougher and tougher and tougher for criminal defendants because it's easy to run campaigns that you're tough on crime. The one thing they can't chip away at, for the most part, is the Constitution. That is your biggest weapon, and you should be using the Constitution in district court to challenge everything that you can, and not just district, but superior. But I like the idea of district because for some reason we don't think about it, and there's nothing more fun and exciting than filing a written motion challenging the constitutionality of a city ordinance or a statute in district court, and everybody else in the courtroom is like, "Oh my gosh, what's he doing?" Let me give you a couple of examples. So I had a case several years back where my client was charged with a panhandling charge, soliciting for alms, begging for money, because he didn't have a license around his neck. And it didn't sit well with me because the more I thought about it, I was like, I don't. There really is no reason why somebody has to go ask the government for permission and get a license to ask someone for help. And it's pretty clear that these are content-based restrictions. First Amendment. This is a content-based restriction on someone's right to free speech. They're saying you cannot ask for money to help yourself. and that there's no way this could satisfy strict scrutiny because the requirements for getting the license were wild. I mean, you couldn't have pled guilty to panhandling without a license at any point in the last few years, and it was creating a serious cycle of poverty where people would lose their job. It takes a long time to qualify for the license. They'd ask for help. They'd get busted for that and plead guilty, and now they can't get a license. So we went ahead and put together like a 4 or 5 page motion to dismiss because the panhandling statute, the ordinance, Greensboro City Council's ordinance, was unconstitutional, and had some great success with it. Ultimately, it ended up catching some media attention, and the city council finally changed that law. But you have that ability. Think about, so First Amendment. You've got all kinds of statutes that might violate people's First Amendment rights. And then related to First Amendment is things like overbreath, under inclusion, all the exciting things you remember from constitutional law. One classic one where you'll see it come up all the time is disorderly conduct and intoxicated and disruptive, because these are crimes that have very, very vague language in them about what your client is or isn't allowed to say. And as you may remember from con law, speech is free. There are limitations. One of those limitations is fighting words, which is a very, very specific and very narrow exception. I mean, these are words that are intended and plainly likely to invoke immediate violent retaliation. And the reason why that's a lot of words is because this is supposed to be a very narrow exception. So I get clients all the time who were charged with this for saying things like F the police. I had a case where a client was leaving the club and was walking right by the National Civil Rights Museum when an officer, who he kept turning around and asking why he was being followed, and finally he turned around and looked at the officer and he said F the police. And it wasn't the wisest decision to make, but he was charged with disorderly conduct for that, which was mind-blowing, because not only is that itself free speech, but there is great case law, Supreme Court case law, Houston v. City of Hill, or City of Houston v. Hill, that says that the police are actually held to a higher standard of not supposed to be violently retaliating. So I filed this great motion on that, and that one is on my website if you want to see it, saying that, look, disorderly conduct in this particular circumstance, he couldn't be charged with disorderly conduct for this behavior because it's unconstitutional as applied. Now, you can always challenge something as unconstitutional on its face, or you can challenge that it's unconstitutional as applied. You might find a district court judge is a little hesitant to invalidate a statewide statute, but they might be comfortable with saying, look, I'm not saying the whole statute's unconstitutional, but it's clearly unconstitutional in this circumstance. So take a look at that sample one. First Amendment is ripe for it. Obviously, Fourth Amendment, I assume you're filing motions to suppress and stuff, so I'm not really including that in this broad category of using the Constitution. But that is obviously another great example of doing it. But you'll end up finding strained ones. I had a DWI case once where my client was pulled over because he was playing NWA's F the Police out of his car. The officer thought he said it to him, but it was the music. But it didn't matter. That was ultimately used as the basis for not only the stop, but then an arrest that then later led to a DWI charge. So I had this weird case where I got to use the First Amendment in a DWI circumstance. But not just the first. Think about the Fifth Amendment. Void for vagueness and arbitrary enforcement. Those usually come in under, those are kind of Fifth Amendment due process challenges. I'll tell you where that comes in a lot is resisting a public officer. There is no more vague a crime than resisting a public officer, a crime that invites arbitrary and selective enforcement. And that is itself unconstitutional in certain circumstances. So be thinking about that. You don't have to be some big constitutional lawyer. to have fun with it. And there is nothing more exciting than walking into district court that morning with a handwritten motion challenging the constitutionality of a crime that your client has been charged with. You should do that. You should do that every chance you can, not only because it's fun, but because ultimately the goal you might get is somebody says, hey, I don't really feel like dealing with this. Or maybe you've convinced the DA based on your written motion of, hey, this isn't really worth it. Let's work something else out. That's an alternative to a conviction. So that's a fun tool. Don't forget that you've got it, and get creative. Look into it. This is an area where you can do a lot of good, and do some of the areas of law that you may have thought wasn't available to you in criminal district court, but is certainly there as a weapon for your arsenal.
Thank you to everybody for sticking with us through all 3 of these videos and through all 10 of our topics today. We really appreciate it again, and we just want to continue to point you to some good resources. And Brennan, do you want to hit on some of those?
Yeah, so I mentioned a couple of times the statutes and stuff. Remember, not everything is in 15A. We all think that's where all the good stuff is, but there's a lot there to unpack. But if you don't have a copy of the North Carolina General Statute book, or you don't have access to one online, get one. You may find flipping through it that you find a gem, something fun in there that you didn't know existed. It can be a bit cumbersome to just jump into a giant book like that. So the best way to kind of narrow, if you know what topic you're interested in and you want to see if there's a statute or a case on point, the broader place to start is with those North Carolina School of Government, the criminal law blog I was telling you about. I keep it as one of the bookmarks on my browser. And then I told you as well, the North Carolina Defender Manual that is put out for indigent defenders is free and available online, published by the School of Government, written by John Rubin. That is really well indexed. So, if you just know you're in the ballpark, like speedy trial, and you want to know what statutes or potential court cases could be useful for you, I'd start with the Defender Manual.
And along those lines, the one other one that I referenced that most of you are familiar with, but is the NHTSA manual for DWIs. Standard Field Sobriety Test, and that's nhtsa.gov. And beyond that, we are working on building attorney resources. We are uploading weekly more motions into a motions bank. These videos will be on there. We will continue to add additional both print material and video material as we go on. And so I just encourage anybody to also feel free to check out that. If you go to Aberle and Wall, that's ABERLEANDWALL.com, and then just click on attorney resources. And that's going to just continue to grow. That's one of our big efforts that we're working on, and adding new stuff all the time. Mm-hmm. So thank you all so much, and we hope to see everybody again on another CLE.
Yeah, thanks everybody. Stay safe and healthy out there.